That was Special Prosecutor Jeff Lang calling Kristen Holzman's Facebook postings irrefutable evidence and the theft trial against her. We're seeing social media messages being used more and more frequently in criminal trials. The defendant's Twitter postings played a huge role in the Rutgers roommate spying trial. You remember Darwin Ravi was convicted in that case. Also at issue are Twitter and Facebook postings in the George Zimmerman trial. So how are the courts dealing with this new form of evidence? We're putting it in focus. Former Judge Ada Pozo and in session law enforcement analyst and contributor Mike Brooks are here to break this down. Thank you both. You know, guys, the defense wants access to Trayvon Martin's girlfriend's social media even. Mike, I'm going to let you have first crack at that. What do you think they're after?
Well, they're looking to put together a timeline because, you know, we've got all these different statements. We've got George Zimmerman's walkthrough with law enforcement the day after, but she is an ear witness. And so she was talking to him on the phone, but there was also a large number, apparently, Rochelle, of text messages. And this is going to help put together that timeline. You know, what was she hearing via text from Trayvon Martin before and leading up to that shooting? That's going to be crucial evidence. You know, and it's always, we always thought about cell records. But now, an early part of the investigation, as a former investigator, these are all things we're looking at. Facebook. MySpace, Twitter.
It would be almost malpractice if you did not immediately in this day and age go and check someone's Facebook page and Twitter page right away, because we do document everything in our lives now, don't we?
We do. You know, even if you have someone, you find someone and you don't know right away what the cause of manner of death is, go on to their Facebook site. They may have posted something in there which can help lead you to find out early on in the investigation what may have happened leading up to the incident. It's just so crucial now. And, you know, it used to be that law enforcement used to get a lot of pushback from, let's say, Facebook or even cell phone companies, but now they are cooperating pretty well with law enforcement. You know, as long as law enforcement goes ahead and gets a subpoena, or if it's going to happen right away, you know, if it exigent circumstances, they'll say, okay, we've got a warrant, a subpoena coming your way. We need this information as soon as possible.
And that's when I want to bring the judge in. Judge, let's talk about subpoenas and warrants, and talk about how in many cases we choose to put our lives out there, but where does privacy come into this, right? Because there are times when, you know, especially when you're talking about Twitter, sometimes you use a Twitter handle as opposed to your real name because you don't want people to know your real name. When does privacy come into this?
That's a great question. And, you know, I think at this point, the social media law and the admissibility of it and the discoverability of it is really at its infancy. I mean, we've seen right now, just in 2012 alone, an 85% increase in published opinions by this time last year regarding social media. So this is something that we're going to see a lot more of. And at this point, the courts all over the country are in different places. Even within states, different districts are all over different places as far as what's discoverable and what's admissible in court. So at this point, I think it's fair to say whatever you post can and will be used against you.
And you know what, guys, I think sometimes that's okay, but sometimes is that always fair, right? Because sometimes it could be used to unfairly tarnish a victim in some cases, and maybe that's not always fair. And I'm going to let the judge take that first, and then Mike, I'm going to let you take that. Judge, what do you think about that?
Yeah, I mean, it can, and that's where the courts have to come in, because like we've seen, for example, in the Trayvon Martin case that we just saw, that the judge is going to allow the defense to see the Facebook postings, the Twitter accounts. But that's very different as to what's going to be admissible in trial.
Okay.
So one thing is what the other side can see, what's discoverable, and another thing is what's going to be admitted in trial and what's going to be made public and what the jury is going to be able to hear, which are two different things. And we're seeing this a lot, not just in the criminal arena, but we're seeing this all over the place in the civil arena.
And Mike, we have. I'm sorry, Judge.
I'm sorry.
No, I didn't mean to interrupt you. Go ahead and finish.
You know, we have people that, for example, bring lawsuits saying they're completely disabled and they can't work, and then they're posting on Facebook their ski trip last week. So this is, you know, this is out there, not just in the criminal arena, but it's being very useful to insurance companies and defense attorneys in the civil arena as well.
You know, even in the corporate world, Rochelle, there are a lot of companies that don't have a public media policy, and I'm telling you, you need to have With police departments, fire departments, Turner, everyone now, if is looking at social media policies. We have a very strict one. Other companies, they don't have it, but you leave yourself wide open because if one of your employers puts something on there that you don't like, and it kind of leaves you open. To scrutiny because you don't have a public media policy. If you don't have one, you need one, especially in this age.
But it absolutely is the first. Let me ask you this question: is this taught now, Mike, at the academy, that this is something that you do as part of your investigation now? It's just common sense.
Oh yeah, I mean, you talk about media relations, you talk about social media, and also when you're talking about training and criminal investigation training. Yes, this is one place you have to.
So
look.
let me ask you this: and what if you have some old school cop that's like, I'm not getting on that Facebook and that Twitter? You better get in the 21st century and do it, right?
You better. I mean, either that or go ahead and retire and come on television and talk about it. No, it's something that you really have to look at as an investigator because it's just another investigative tool that's out there for you. And and like the FBI, they have specialists now that look at computer, that look at social media, that just specialize as part of the evidence response team that specialize in retrieving information from social media and from computers.
So basically, police departments are having to figure this out. And as the judge said, the court systems are having to figure this out as well. Judge Pozo, Mike Brooks, thank you both very much. Appreciate it.